Good morning, good afternoon, good evening, depending on what part of the world you're in. I'm Maria Volpe. I'm a professor at John Jay College of Criminal Justice at the City University of New York. These events are co-sponsored by the Association for Conflict Resolution of Greater New York and the City University of New York Dispute Resolution Center at John Jay College of Criminal Justice. I started them after 9/11. This morning is our 295th gathering. We used to meet in person until the pandemic started, and starting in April, we met at John Jay College physically. Since the pandemic started, we've been meeting online. All of these sessions are recorded, as we mentioned, and Nikki will post the link for you to access them all on YouTube. They're also posted on the ACRGNY and the John Jay College websites. Each month, these events are made possible by a wonderful committee that I'm a part of, including Matthew Latimer, Nikki Borofsky, Sherston Pugh, and Chloe Choi. I am going to turn this over to Nikki to introduce our speakers. Wanted to share that next month the speaker will be, Josh Weiss from Beth Path University, who will be talking about his new book, Getting Back to the Table. His topic will be When Failure Happens in Negotiation, What Do You Do? Okay, I am thrilled once again to have colleagues joining us who will be able to share their work, their thinking about an aspect of the work in this field, which is incredibly diverse, as we were discussing earlier during the informal chat part. And it always takes a village for us to pull these off. So I'm thanking Matthew Latimer for connecting us with Delton Henderson, who connected us with Greg Kochansky. I'm not sure I'm pronouncing your last name correctly, Greg, and to Adam Shoneck. Thank you so much for being a part of this morning. And take it away, Nikki, to more formally introduce our guest speakers this morning.
Thank you, Maria, and welcome, everybody. Welcome to the first Roundtable of 2026. As we open the year, we do so at a pivotal moment, not just a new calendar cycle, but a very real shift in the terrain of our field. We are now operating fully within the world of AI-augmented dispute resolution, not just in theory, but in practice. We have arbitration demands drafted by LLMs, responses generated with AI-assisted tools, procedural templates proposed by machine learners, and behind it all, the rise of decision support systems that don't just process language, they begin to shape it. At the forefront of this transformation is the AAA NYC-DR, which has not just dipped its toe into these waters, but plunged in for the long swim. Over the past year, the organization has rolled out a lot of very cutting-edge and innovative initiatives. The AI Arbitrator Initiative, now being used in documents-only consumer and construction cases, tools that pilot and lead parties to generate demands and replies using LLMs with human review still, formal guidance for arbitrators on the use of AI, figuring out how we draw lines around ethics and accuracy and proper consent, and a public-facing AI governance framework designed to prioritize fairness, transparency, and human oversight. This is not a someday conversation, it's happening now. And today we really get a chance to look at what that means, not just technically, but ethically, strategically, and relationally. Because this isn't just about faster filings or smarter forms. It's also about who gets heard, who gets helped, and what we're building or giving up as we invite and implement more sophisticated machines and intelligences into the process of justice. To help us navigate this, today we are joined by three remarkable guests, each of whom is shaping this work from a different vantage point. I'm going to very briefly introduce them, and hopefully they will fill in all of the gaps that I'm leading. Delton R. Henderson is a seasoned neutral and educator whose legal work spans arbitration, mediation, and court-annexed programs. He also serves as general counsel for the American Society of Music Arrangers and Composers, which I think is a very hot area for the interactivity of artificial intelligence and our future. So he brings a really special mix of procedural rigor, very rigorous. He's helped design the poll questions for today, and deep experience across both formal and creative sides of conflict. Greg Kochansky is Vice President of Thought Leadership at the American Arbitration Association and author of a very cool weekly newsletter, AI in ADR, which is sharp and witty and really changes the relationship between generative AI and the dispute resolution field. His writing really tracks what's going on and how AI is reshaping the language that we're all speaking. Lastly, Adam Shoneck is another vice president at NYC-DR who has spent more than 15 years helping to manage and redesign high volume arbitration systems, especially in the world of consumer and self-represented disputes. And these are areas where AI is really playing an important role in helping us do better, but also presenting some risks. He brings a practitioner's eye and a systemic perspective on how we can make complex processes more usable, transparent, and just. So let's get ready for today's conversation. We'll be including a live demonstration of AI-generated filings, tour of some of the cool tools that are currently in use at the AAA, and a deeper dive into a discussion about what this means for us. We're going to tinker, we're going to think, we're going to push back where it counts, because that's what this space is all about. So with that, I want to hand the stage over to our speakers to get us started. Delton, Greg, Adam, the mic is yours.
Thank you so much, Nikki, and welcome everyone to the panel and the other conveners. We want to thank you for your participation and the invitation to be a part of this event. I'll just take a quick minute to run through these bullets, which should establish for us a focus in terms of intention. By the end of the session, we hope as participants that you will be able to explain the stages of consumer arbitration process, create a list of AI best practices in ADR, and apply this repeatable AI workflow prompts for safe, ethical use as a drafting tool. And then engage in dialogue on a global scale regarding access to justice. We'll first be hearing from my colleague, Adam, followed by Greg, and then I will come back to introduce the interactive portion of our presentation today. Thank you again.
Thank you, Delton. So my name's Adam Shoneck, and I'm going to talk a little bit about the AAA arbitration, consumer arbitration process, so we can see where AI can and is being used in this process. But just some background on the AAA for those who don't know. We're a 501c3 not-for-profit organization. We're celebrating our 100th anniversary this year. We've been talking about it for a long time, and now it's finally here. And we are the largest provider of arbitration services in the world. We do hundreds of thousands of cases a year when you include our state insurance caseload that we do for New York. So we do quite a volume. In the consumer process, it's important to maintain fairness and transparency. We publish all consumer awards, and the party names are redacted, but the arbitrator names are not. So that's public, and that's something that most people don't know. We also have our consumer due process protocol, which ensures a minimum due process standard for consumer arbitrations. Our consumer clause registry which, although this is a high-tech program, is a considerably low-tech solution, but it's the only one of its kind. NAM has one, which is optional. This is mandatory for any business who wants to have us administer their cases. They have to register with our Consumer Clause Registry, which is, like I said, public, to make sure that the process is transparent. People know who's using arbitration, and it's not locked away in some contract. In addition to that, we have our consumer arbitration rules, which really distill the principles of the consumer due process protocol into a workable administrative framework. So we'll start with going through the stages of the consumer arbitration process. So first is initiation, where you file the case. So you file a demand for arbitration along with a contract and a filing fee to American Arbitration Association, and serve that on the other party. Respondent then has the opportunity to answer that filing, and formal pleading requirements are not followed under the AAA. So this is where we are seeing quite a bit of AI use in our cases, is people using AI to help them fill out their demand or provide a statement of claims. And some people have even taken it to the point, non-lawyers, of doing repeat filings with the assistance of AI. So it is happening. It is out there. I'm sure those of you in other spaces are seeing it too. But after the respondent is able to submit their answer, we move on to arbitrator appointment. The arbitrator is the one who decides the case, and it is a final and binding ruling. In a consumer case, they're appointed by the AAA, and we are using AI arbitrator search tools to assist us in appointing arbitrators to these cases. Instead of just keyword searches, we're able to do semantic searches now to better pair the dispute to the arbitrator for the case. So we're able to get better matches. Our panel of arbitrators for consumer is specialized in consumer matters, and like I said, we are using AI search to better match them to cases. Once the arbitrator is appointed, we schedule a preliminary hearing. That's where you set out the schedule of the case. We've experimented with AI in this stage several years ago, where we took a transcript of a preliminary hearing, we fed it through AI, and had it produce a scheduling order for us. Turns out it took more work to get the scheduling order into the format it needed than it was to just have the arbitrator do the scheduling order. But you live and learn, and so maybe at some point we will be able to get back to that. But the point of the preliminary hearing is to set out the schedule of the case. So somebody asked, what is a semantic search? So that's keyword search would be like, if I put in dog, it would return any search that included the word dog. But semantic search might include pets as well, something like that. So it understands there's a relationship there, even though it's not exactly the same word. After the preliminary hearing, there's potential for motion practice, and this is another opportunity potentially to use AI in the drafting of documents, although I don't know quite where we are with that. I guess it's use at your own peril, right? That you want to check everything, but motion practice is where the parties will, set out any dispositive motions that they feel are appropriate or other motions that it might affect the case. After that is the evidence discovery phase, where the parties exchange their evidence or conduct discovery, followed by the hearing itself. The hearing is where everyone gets together, maybe virtually or in person, and talks about their case for the arbitrator to decide. That could be a live hearing. It could be a desk hearing. A desk hearing would be actually on the document. So where the parties don't get together, they just exchange documents and the arbitrator makes a ruling on that. We are using AI in the hearing space to transcribe hearings. AI transcription is very popular and highly accurate and less than the cost of a traditional court reporter. So we pair with a service that provides that to our cases. Post-hearing is where we've had the hearing and we're not sure if we have all the briefs ready or all the evidence submitted. So the arbitrator may at that point say, okay, I need additional briefs. When they're satisfied that they have all the evidence that they need, all the information, they will close the hearings and start on the award. Excuse me. Our arbitrators are able to use a tool called ClearBrief, which helps them in creating timelines of information and do some other things with AI. It helps them site check as well. So in the award phase, they're probably using that tool to help them research the case and build their award. But the final award is then issued and the case closes. There's very few appeals in a consumer or in arbitration, although in consumer arbitration, appeals processes, appeals provisions in contracts are actually not uncommon. So interesting perspective from consumer arbitration there. But okay, so that's the consumer arbitration process. Greg, am I tossing it over to you now, I think?
Yeah, that's right, Adam. Thank you.
Okay.
Good morning, everyone. And Nikki, thanks so much for your introduction at the top and for dropping a link to our weekly AI and ADR newsletter in the chat. Just to fill in a little bit more about where I'm coming from, I am a lawyer, although I haven't practiced in quite some time. I co-manage the AAA NYC-DR Institute, which is the AAA's internal think tank. We focus on several areas: access to justice, court-connected ADR, fairness in arbitration, and artificial intelligence in ADR. I'm also involved in building AI tools at the AAA, including our recently launched AI arbitrator, which Nikki had also mentioned. And I'm a member of the AAA's AI governance committee, which sets guardrails for how we use AI across the organization. So everything that I'm going to tell you is viewed through that lens of my work experience at the AAA. So why does AI matter in alternative dispute resolution? Well, when we talk about ADR and arbitration in particular, it's important to remember what it is an alternative to. And of course, that's courtroom litigation, which tends to be a heavy process where it can take many months or even years to resolve a dispute and at significant, sometimes prohibitive cost. The promise of arbitration is faster, more efficient, and more cost-effective dispute resolution. And a cornerstone of arbitration, at least in my view, is innovation. It's an adaptable process, and it's a matter of contract between the parties that can be tailored to their preferences. It's flexible, and there are plenty of examples of technology being leveraged to improve that process. An obvious one, the pandemic made in-person hearings untenable, and parties and ADR administrators quickly pivoted to virtual hearings. Now that's become common practice, even for non-arbitration settings like this one. It makes scheduling easier, it saves on travel time, and video conference technology has become so good and reliable that it's an effective substitute for in-person hearings. AI presents us with a similar, but I would say more profound opportunity to make arbitration more effective as a process. An example of that, recently, the AAA launched an AI arbitrator with an initial focus on more efficiently resolving the most routine construction industry disputes. Parties who agree to use the process submit their arguments and their evidence through an app that's available on our website, and a quite robust AI system on the back end ingests all of that information and decides which party should win and drafts a reasoned award. Of course, there's still a human arbitrator in the loop to ensure the outcome is fair. But this process saves a great deal of time in terms of determining the timeline events and explaining who should prevail and why. Now, the AI arbitrator does not help parties to present their cases, but parties can use AI in similar ways, and that's what we're going to be talking about during today's session. Not only does AI make it possible to present a case more efficiently, it makes it easier for non-lawyers to present their own case more effectively. That said, this is not an automatic thing. It's probably not a good idea to simply upload a bunch of information and documents, press a button, and trust the AI to do the rest. Human judgment still matters, and AI is merely a tool in service of that. And I think that's a really important first principle that we should proceed from here. Most people use AI through a chatbot interface. OpenAI, Anthropic, and Google are the most prominent players in that space. And I imagine most people on this call have some experience using those interfaces. But what we're talking about today is how you can leverage even these simple interfaces to perform quite complex tasks in the context of arbitration. AI can help a party or their representative to organize facts into a coherent timeline. It can serve as a thought partner that helps you test and refine your arguments. It can help you prepare for witness examination by generating questions, identifying inconsistencies to probe, and suggesting follow-up questions. And it can help with even more mundane tasks like just summarizing party submissions and lining up evidence with key issues in a case. There are also more sophisticated AI tools that are designed specifically for legal tasks, for instance, Harvey, or AI-enabled tools from legacy legal research services like Westlaw or Lexis. The benefit of using these tools is that they have direct access to legal resources, case law, statutes, practice aids. They also may have guardrails in place to protect confidentiality of case files and to produce accurate outputs tailored to the legal domain. However, these systems are not perfect. They also can be quite expensive, and they might be out of reach for individuals or smaller firms or enterprises. So regardless of whether you use a specialized legal AI tool or a consumer-grade AI tool, it is important to keep the risks in mind and take precautions to mitigate those risks. And there are two major risks that I'll cover very briefly. The first one, which I'm sure we're all well aware of, is confidentiality. Arbitration in particular is generally a confidential process. The parties' filings and evidence are not available on a public court docket for everyone to see. The safest rule of thumb is that you should not paste or upload anything into a consumer AI chatbot that you would not share in a public forum. And some consumer AI services state that they may use user content to improve the model performance unless you opt out of that. In contrast, some of the enterprise and legal-oriented tools make stronger commitments, such as no model training on customer data and sandboxing that data to maintain or at least bolster data security. But you should still confirm, even if you're using those tools, the exact terms for your plan and the specific workflow, data retention, all of that. The second major concern that I'll cover briefly is inaccuracy. AI systems are reliably good at producing drafts, organizing information, translating complex concepts into plain language, and generating checklists that reduce avoidable errors. However, AI systems are not reliably good at guaranteeing truth. And that's because they generate text by prediction. It's a matter of probability, which is a fuzzy thing. As amazing as these tools are, you can't bank on their outputs. You have to, verify rather than trust. The typical way we think about AI inaccuracy is in terms of hallucinations. A large language model can fabricate plausible seeming citations, quotes, or factual claims. But AI can be inaccurate in more subtle ways as well. It can emphasize the wrong facts or make a suboptimal argument. Anyone using AI for work that has real-world consequences, and here we're talking about legal work and arbitration, has a responsibility to verify outputs from the AI. You have to apply your own human judgment. That means checking citations, checking quotations, not only verifying that an authority exists, but that it stands for the proposition it's being cited for. And ultimately, the human using the AI tool is responsible for how they use the outputs from that tool and the accuracy of what they're presenting to an arbitrator or in any other real-world context. So what we're going to be covering for the rest of this session, and I'll hand this off to Delton in a moment, is how parties can use AI in arbitration. Practical strategies for prompting AI models to produce useful outputs. And one thing I hope you'll keep in mind is that you don't need to draft prompts from scratch. I use AI dozens of times every day in my own work, and it is pretty rare nowadays that I will write a prompt from scratch unless I'm doing something very basic. Instead, I'm going to tell the AI what I want to accomplish and ask it to draft an effective prompt. And this is the single most powerful insight that I can offer you. You do not have to reinvent the wheel every time you want to prompt AI. Tell it what you want to accomplish, review the prompt it produces, maybe edit and iterate on that, and then use that prompt instead of your own, writing from scratch. But after you do all of that, be sure to apply your own human judgment to the output. We all have the responsibility to do that. Delton, I'm going to hand it off for you. I believe we have some polling questions. And Delton, I believe you're on mute.
Yeah, I was just going to say that.
You can see my lips moving and nothing coming out, right? Okay, I apologize for that. We do have a couple of polling questions for you, and we're going to start with the first polling question, number 1, which asks, have you used generative AI for legal work?
People are already voting, coming in. If you don't see the polling question, please feel free to pop your response in the chat. We can integrate that as well. Okay. Over half of the people have responded.
Okay. It looks like the overwhelming majority of people have never used it, or tried to use it in the context of legal work. The second category is yes, but
oops, sorry.
Oh, yeah. And the second grouping is yes, occasionally or regularly. So that's great. So should I stop sharing or would?
I can stop sharing. We
Oh,
can go on
okay.
to the next one. Just some comments. People ask if mediation is included in legal work for you,
Personal.
or in the scope of your question. Should we go on to the second poll?
Oh, I think yes. The question is intended to gauge the use of AI in all forms of legal work, not just ADR, but yes. Polling question number 2. And I apologize, but because I'm sharing my screen, I don't see the chat. So if I don't respond, it's not that I'm ignoring you. I don't see it. So thank you, Nikki, for keeping me honest.
Poll 2 is up, and people are starting to vote. So poll 2, for those of you who are not on audio only mode, is your biggest concern about AI in legal drafting is accuracy and hallucinations, B, confidentiality, data security, 3, ethics, rules, professional responsibility, 4, cost, access to tools, or 5, don't know enough to assess yet. Okay, I think most of the people have responded now.
Oh, okay. So
Right.
almost half of the people have accuracy and hallucination as their top concern. And that's a legitimate concern to have, certainly. So I'm going to stop sharing that and move to the next slide. Before we get into the actual exercise, I wanted to share a little bit with you about my background and how I, came up with the idea of offering this as an interactive exercise for everyone. As an arbitrator, I see the full spectrum of pleadings, from meticulously prepared cases brought by seasoned counsel to earnest but disorganized filings from non-lawyers trying to navigate this process of arbitration on their own. And across that spectrum, I've come to believe that the ethical use of generative AI in the pleading process offers a meaningful benefit for everyone who's involved, parties, counsel, and neutrals alike. And let me be clear about what I mean by ethical use. I'm not talking about having AI write your entire case or submitting machine-generated content for professional judgment. I'm talking about using these tools thoughtfully with appropriate oversight to enhance the quality of pleadings and improve the access to a fair process. When used responsibly, AI can reduce cost, increase efficiency, and ultimately lead to better prepared cases, which benefits the entire dispute resolution system. I want to discuss 2 categories specifically of ethical use that I find particularly promising. 1, how attorneys can leverage AI to elevate and refine the claims they raise. And 2, how self-represented parties or non-lawyers can use AI to help them understand their procedural requirements and how to present a valid legal claim. On the lawyer side, I think lawyers face constant pressure to be efficient without sacrificing quality. And in the early stage of a dispute, counsel must evaluate potential claims, assess their viability, and make strategic decisions about which to pursue. This process traditionally involves significant time reviewing precedent and analyzing facts against legal standards and drafting and redrafting pleadings. Generative AI can serve as a valuable thought partner in this process. When lawyers use, I think, AI in this way, clients may see reduced legal fees because the research and the drafting process become more efficient. Cases arrive before arbitrators in better shape, with claims that are more focused and better supported. And attorneys can devote more time to the strategic and interpersonal dimensions of representation that generally require human skill. Now, from the self-represented or non-attorney point of view, one who faces a very difficult challenge in preparing legal documents is obviously a person who has no training in doing that. These individuals often have legitimate grievances, but lack the legal training to translate those concerns into properly structured claims. They may not understand that a demand for arbitration should, what a demand for arbitration should contain, what procedural steps they need to follow, or how to present facts in a way that supports their legal position. This is where AI can genuinely be transformative. A self-represented or a non-lawyer party can use AI to ask basic questions. For example, what does filing a demand mean? What information do I need to include? What happens after I file? Importantly, the access to justice implications here are very significant. When self-represented parties arrive with better prepared filings, they can too participate more meaningfully in the process. And arbitrators spend less time sorting through confused or incomplete submissions, and the system as a whole becomes more efficient and equitable. What I have on the screen here is an example of a demand for arbitration under the AAA administrative case. And I'm trying to, let me move the poll here. Okay, there we are. And as you can see, and under number 2, what's required is a brief explanation or briefly explain the dispute. That's the call. And why is it, so vague or broad? Because the Federal Arbitration Act, California Arbitration Act, New York's Arbitration Acts do not incorporate the federal or state rules of civil procedure. For an arbitrated case to begin, generally a simple statement is all that is required. And this is referred to as a demand. And it's for that reason that I wanted us to collaborate on creating a demand for arbitration and a response using the assistance of AI. I've selected an AI tool that is free and available rather than one that would require a subscription fee or something, because of course the levels of accuracy would be very different. But this is a version that everyone would be able to access, and the results are to come. Let's see here. There is one other polling question that I would like to ask before we get to the actual exercise, and that is polling question number 3. This is, or do we have it?
Launching now, polling question number 3. In the demonstration to follow today, what do you want to see? 1, how to write effective prompts. 2, how to catch AI mistakes. 3, whether it's actually faster than doing drafting manually. Or 4, how to use it ethically. Oh, there seems to be a relatively even split, Delton. You have a lot of work before you.
Right. Okay, we're going to end the poll here, and we're going to start the exercise. So in the interest of time, I actually ran the prompt in advance and just saved it as a tab. So we're going to be working from a process that has already been completed. I will, let you know though, with each prompt, the results were delivered in less than 2 minutes. So we're going to switch now from this. Did everyone have a chance to read the prompt? You may have also received a handout with the prompt in it.
I just posted a link to the handout. I will post it again. And I can also pop a copy of the prompt in the chat so that everybody has it kind of in that window as well. And as we're doing this, we're switching in real life to the intelligence of choice of Delton. And one of the questions as we were switching was what kind of training, if any, do people using the AAA's AI arbitrator use? So just let's have that in the minds of the VPs from AAA as we continue forward. But Delton, we've got it up on screen. Everybody should be able to see the ChatGPT prompt now.
Oh, can you see it? Oh.
Yep.
Oh, so I have something else here that is in front of it. Is it full screen?
It is now full screen, yes.
Okay.
Scrolling
I apologize for that switch. I know that when you're passively looking at text move and it goes so quickly, it can be a little jolting. So this is essentially the prompt that was contained on the slide presentation. And we're using ChatGTP, the basic version of that. And, I basically dumped that prompt here with a few of the facts. And what it did is it said, okay, I get it. This is what I'm going to do. I'm going to prepare this concise demand for arbitration suitable for filing under the consumer rules. And what we get is a heading. We get, the administrating agency's title, and then room for us to fill in information about the claimant and respondent, an introduction of the parties, jurisdiction and venue. I'm going to slide through this just to show you what's all here, and then we'll go back to the top and examine each section. Factual background, claims for relief, damages, hearing requests, a list of proposed evidence, a conclusion, and then a salutation. So let's start here in the introduction. Based on the prompt, if you remember what was in the prompt, how would you grade this summary of the facts that were presented? Would you say that the AI understood what the scenario was, the complaint? And now I should be, or I'm not able to see the chat, am I?
Just pop the question into the chat. Anybody should feel welcome to put your grades in the chat. Everybody's feeling shy.
Okay. Well, I will say that, if I had received this document formatted in this way, I would be pretty pleased with it. I mean, it seems to check off the boxes of, of most of the concerns. Now, what I want us to do is to look a little bit deeper and establish whether or not the AI accurately reflected the information that was fed to it. And we'll start in the paragraph that is entitled jurisdiction. You'll notice that in the first full sentence, but second line, it says, and the amount, and maybe I can highlight that for you, and the amount in controversy falls within the scope of those rules. Now, we do know that for establishing federal jurisdiction, there is an amount in controversy requirement. I will tell you, because, well, I know that there isn't such a requirement in the AAA rules for consumer arbitration. So this would be, a clear fallacy that the AI, generated on its own because it felt it needed to have that element there. And certainly something that only a human with knowledge would have been able to, identify. And certainly as the arbitrator receiving this, it would raise red flags and certainly probably weigh against the credibility of the person who submitted it. So this is why it's important, that, if you're using tools like this, the structure may appear extremely well organized and extremely thoughtful, but it's still important, for the human to get in there and examine the content to make sure that it's accurate. There were a couple of other points in this paragraph that I personally took issue with, and that the other one that's significant is the second sentence says that the arbitration agreement requires. Well, I didn't mention that there was an arbitration agreement. I simply said I wanted to file a demand for arbitration under the AAA consumer arbitration rules. So that, again, would be something that in your fact checking, you would be able to catch and, amend appropriately. We'll move now to the facts section. And again, what I like about this section is the order and the preciseness that the AI applied in terms of isolating specific facts as part of a singular thought, a numbered paragraph, right? And this is something that I don't know if this is true for all of you, but it certainly is true for me. Sometimes thoughts just come at, as a floodgate, and it's very difficult to, sift through them and know when an appropriate place to stop, a paragraph and start a new one. And so you struggle with that process. It seemed not to have that problem. So, the facts are organized sequentially. And I think they also are organized in the order of the claims that it identified, which we'll get to later, which again, that's quite brilliant work, What I did find questionable in this fact section, though, are 2 points, and they're mostly about modifiers. There is in 3. Promptly. Now, those of us who are familiar with product liability claims or similar causes of action, implied warranty claims, know that notice plays a key factor in terms of determining your eligibility for a remedy or right to recover. And so using the word promptly here, it could or could not be construed as a hallucination by the AI. because we didn't say that that the notice was provided. I think the fact says indicated that within the first 90 days, there were several attempts to repair. And obviously you read into that there had to be notice for the attempts to repair to take place, but there was nothing to suggest that that was done. Well, maybe 90 days, maybe putting the 90 days in there suggested to the AI that this had to have happened immediately. I don't know, because I can't, well, I could ask it maybe, and why did you use the word promptly here?
Delton, as you identify the shortcomings in the response, does that spur you to fact check more, or to draft a different or better prompt, or to iterate? What's your process with what happens when you find that there are things that are inaccurate or not to your liking?
Yeah, so that for me is where I start engaging with the technology, and I refine the prompt. I haven't used extensively the prompt building tools that are out there. I typically like writing my own because then I can control kind of the narrative. But I do believe that is another opportunity for the human to exercise responsibility, and thoughtfulness. When you find inconsistencies or inaccuracies like that, it doesn't prompt me to mistrust the AI, because again, I would not have been able to generate this first draft in 2 minutes. So if I have to now spend 20 minutes or 30 minutes reviewing it, well, that's much better than having spent 2 or 3 hours to pull it all together. And certainly, I think one of the examples that I've received or that I've heard, mentioned in this space by people who are perhaps even more experienced using AI in the context of legal work, is that if you were to give an assignment to a first-year law student or a summer associate, you're not, as the partner, the managing, the supervisor, going to just affix your signature at the end of the first draft. I mean, there is going to be some, scrutiny that is engaged, and so the same is due and expected. When you're using tools like this, the advantage, I think, if there is an advantage, is the time. I think that the time that it takes, and then ultimately the cost. If there is ethical billing, then you're not charging nearly as much for the work, because it doesn't take you that much time. But yeah, that's kind of what I wanted to show you, with this example. And, here again, I'm not sure, but I thought the format and the information that was provided to me was decent enough that, I would do this or use this kind of, tool for the purpose of organizing thought. I'm interested to hear, whether anyone else has any trepidation. There were more than half of the people said that they were, I don't know, if less likely to use AI in doing this kind of work because of its hallucination, or if that was just a concern for you.
Would anybody
Would-
like
would you-
to raise their hand or pop in the chat what your sense is, and if this little demonstration has moved you at all?
In one direction or the other.
Nadia?
Hi, Delton. Thank you so much. Nice to see you again. Happy New Year.
Yes.
I really, just in terms of first production of draft, right? Like I think what you mentioned about senior partner is not just going to send out what a junior associate does, just stamp their name on it. And I think that's like a learning, it should not be a learning process, I think, for the legal people who are legal professionals, because why anything, if they're saying like, oh, cats are involved here and that's not the case, everything should be reviewed and read. So I don't see, obviously one of my main concerns is kind of confidentiality and how LLMs are learning from data. And I think that's very important, like in terms of making sure what you're putting into these AI machines is kind of protecting confidentiality, which is always a concern, even if a lawyer is talking outside about confidential information, you have to think about who's around you. I feel like, in the internet space and like using AI should also come with that same thing, but anything that makes us more efficient, I am definitely a proponent. I am scared of this stuff, but I'm trying to force myself to learn it because, this is where we're at. So there's no like, let's rewind, because we are forging ahead. So, thank you so much for this presentation. It's really, great to get more exposure to it. Thank you.
Oh, thank you for your comment.
And some of the comments have been along the lines of, wow, this is interesting, but it requires a lot of knowledge for the human reviewer to analyze what the AI has put out. How does this help people who might be in a situation where they have less knowledge, say a pro se party or a non-lawyer or somebody who's not as familiar with the AAA arbitration rules, to catch those hallucinations or spots where conflicts are troubling?
So, I mean, at my level of review, of course, it's going to be very different, obviously, because I have the training. But for a person who doesn't have the training, my inclination, it's certainly something that I counsel my clients to do when I am engaged as counsel. You need to ensure that you understand everything that you're being presented with before you fix your signature to it. And if there is something that I'm presenting to you as a document that contains a phrase that is unfamiliar, you have to ask. And we'll take as much time as is necessary for you to get the clarification that you need to feel comfortable about moving, on with that in that process. So here, I'll give you to that question, I'll give you a great example. In the damages section, the AI generated a statement that says any applicable attorney's fees and costs recoverable under AAA consumer arbitration rules or applicable law. Well, I'm thinking, well, how do you generate attorney's fees and costs if you're a self-represented party? And so it prompted me to do more research on that question. And it turns out that there is precedent under New York law where people have been successful in reclaiming attorney's fees and costs. I think it was framed more like cost associated with preparing the case and bringing the case and that sort of thing when they perform the duties of an attorney, essentially. And I think there were even some cases where attorneys who were self-representing was representing themselves also were able to recover attorney's fees in a matter. And and where that question rests in terms of authority is all over the place. I mean, it's a very fresh issue, which I thought, here I actually learned something.
And that was actually a
from
question or a comment that Marianne made a little bit earlier in the chat of, the GPT assumed attorney's fees, and yet there's pro se. Where are these coming from? So it's great that you used it as an opportunity not to just say, no, you're wrong, but to inquire as to where the kind of origins of thinking that might have come from, and actually enrich your own understanding about potential fees that are recoverable.
Right. I use a version of AI assistance for certain types of assignments, which is not the free version of ChatGTP. And in that version, I'm actually provided with reasons, and I'm provided with hyperlinks to the sources. And so it's a much more robust kind of result. What I wanted to demonstrate, and that of course is a paid service, so I mean it's a little different, but what I wanted to demonstrate is what is available on the sort of modest means level, or in this case no means, because ChatGTP is free. There are tools out there, and I think even Greg had alluded to them. Harvey is one of them that is, quite amazing, but very expensive. Thousands of dollars a month. I mean, so I don't, foresee everyone being able to, to use those tools, but still these are. I don't know if there is a word that would suit it. I don't want to say reliable, because that is not what I'm suggesting. It is helpful. It's helpful. That's what I have. On the demand side. So if we stroll down to the next prompt, this was my attempt to.
Like me?
Oh.
Yeah, I'm not gonna take a shower. There's no water pressure. I wonder if they're working on them.
Oops, sorry.
Okay. Okay, so the next prompt that we have would be to draft a reply. So this is assuming the opposing position, and I give it a little bit more information, and I act as if I had some legal knowledge, whereas with the initial prompt, it was not intended to convey that idea at all. So, and this is what we generated. What I found helpful here is again, the precision with which the AI approaches each task, and so, well, again, I made this proclamation earlier, and now repeat it. I don't know if you remember the character from Star Trek named Data. He was an artificial intelligence. This is a Star Trek: The Next Generation. And when I was in law school, this is what my fellow classmates would refer to me as, just because that's what they thought was appropriate. And so I appreciate this precision of structuring words, and or thought that the AI is able to provide us with the understanding, again, it bears repeating, it's not signature ready. I mean, it's still something that needs to have a person, review. And I think we did one other set of questions, which I wanted to, I think, open the floor Well, let me ask if Greg, would you like to say anything more about prompt generation and what your experience has been, using tools to and how that might maybe even affect our outcome here?
Sure. There are specialized prompt generation tools that, say, OpenAI or Anthropic or any of these LLM companies provide. But I think that just the standard chatbots are pretty good at this already. So I'm not sure if you need a specialized tool. One thing I would consider in this context, and you have to think about confidentiality, of course, as we discussed, is that when you upload a prompt, you can usually upload documents with it. So for instance, here you could take the consumer rules, the AAA's consumer rules, and upload them with the prompt, and perhaps that would be helpful in terms of focusing the LLM on that particular information, or on the latest version of the rules in the event that perhaps its knowledge cutoff preceded a change in the rules that now apply to the dispute. So there are considerations like that, ways that you could refine things, or perhaps there's information that's not confidential or that you feel comfortable, would feel comfortable posting on the internet or whatever, that someone could upload that might help the AI to refine things. And then separately, this isn't really responsive to your question, Delton, but I think a way of framing this, we're looking at the defects in the output from the AI and thinking, well, is a self-represented party, going to just submit that without knowing what could be done to improve it? The fact remains that it may very well be a significant improvement over whatever the self-represented party might have drafted themselves, just because they're not a lawyer and they don't have the specialized knowledge. They've never drafted a demand before. And so, just because it's imperfect doesn't necessarily mean that it's worse than the alternative to using AI. And so I think that's a big philosophical question, and it does shift some burden onto the arbitrator and perhaps onto the other party, where they may be fact-checking some filings that have been AI generated. And that's a significant question that is open to debate. But I just want to point that out. I think that was pretty impressive to see what the outputs were, notwithstanding the defects in those outputs.
There are two questions. One might already be a little bit asked and answered, but one was about kind of the ethical guardrails of the AAA's AI, in the sense of, is it potentially giving information on how to improve a presentation, or what evidence to include, or how to refine arguments. And I don't know that's what the AAA arbitrator AI does, but maybe in the context of even using like a chat GPT, is this in your mind considered practicing law? And how does it maybe impact the non-lawyers ethical use? Just from what I've noticed, there's usually guidelines. When you type something into ChatGPT, they're like, consult a human lawyer or a human judge. But what is your sense been of that kind of a use or dangers?
First of all, just to clarify, the AI arbitrator, and to my knowledge, any of our AI tools, none of them really help parties to refine their arguments. So that's not an area in which we've delved. But in terms of whether using chat or one of these other services facilitates unauthorized practice of law, I mean, that's a huge philosophical question that I don't want to touch with a 10-foot pole, because I don't really even know where to begin in terms of analyzing that. But I mean, the fact is that individuals who are not represented by lawyers can represent themselves in arbitration or even in court. And so, it raises questions for me about, if that's possible, then why shouldn't someone be able to use any tool, whether that's Westlaw or ChatGPT, to enhance their ability to present their case? So that's probably the first principle that I would start from.
Do you find just...
Go
go ahead.
No, I'm sorry. I wanted just to add a little thought, a reflection on that question as well, from the perspective of unauthorized practice of law. Let's uh, define it as a concept, right? In order for there to be an incident of unauthorized practice of law, you have to have a person who is not licensed to practice offering advice of a legal nature to someone else. What we're discussing here is the use of technology to assist oneself um, in the presentation of a case. Um, and that is I don't think that the subject of unauthorized practice of law would naturally arise out of that scenario. It would, however, if I don't know if there is someone on the call who's not a lawyer, but there is someone who that is not a lawyer who uses AI or some other so one of these tools to then advise their neighbor, who then uses that information to submit it to wherever, then yes, I mean obviously there is a significant issue. But you had another point though, Nikki, I'm sorry.
Oh, no. Another question that came up was, might the use of AI benefit a certain type of party with certain characteristics more than another type with different characteristics? And in so doing, could AI be perceived as inherently unfair and not neutral, and that it might impact the likelihood of who's to prevail? In my mind, it just popped up that most of the parties I come across are more giving Worf than Data, if we're going to stick with a kind of Star Trek analogy. So just your thoughts on how the interplay of AI and different people with different personalities might impact the process.
So I have experienced participants who have uh, neurological problems, or they have cognitive, challenges or deficiencies, and they are probably good candidates, for the use of a tool such as this to help them organize their thoughts. The opposite of that, where it would be used as a sword, I'm not sure that I understand how that's possible, where it would put a person at an advantage over another person. Because it's still ultimately information that's readily available to anyone who's willing to search for it, but some will take longer than others to find it. you know um I'm not sure if that responds to the prompt or the question, but
I think these are big philosophical questions
yeah,
as
and I love
well.
that. Yes.
Does anybody else have a question that they would either like to ask live or put into the chat? There was a question from Ramona asking if any of you have used AI in coming up with either mediation agreements or other sorts of maybe interim kind of orders in arbitrations based on what parties have said or the hearings.
No, no. I'm probably too much of an, maybe that's where I will admit to having an ego. I'm not willing to surrender that process to someone else. I like thinking way too much. So personally, I have not. I typically will use it more in terms of fixing grammar. For sentence construction, I'm still reminded that whenever you use past participle, you have to have an auxiliary verb. With my AI that I use, it gives me that level of instruction. And so yeah, I really I use it differently. So
Yeah, and I think
Anyone
that's
else
what's one of the challenges of doing a live demonstration with a publicly available model is like it gives the lowest kind of level of potential output. As Greg was saying, you can upload the the cleaned kind of arbitration agreement respecting people's confidentiality. You can upload the applicable rules and get a much more robust and tailored response potentially. So what what you're demonstrating here is kind of a just a ghostly iteration of what you probably use in your daily life when you're working.
Yeah.
I will mention that there's another sort of design or prompting pattern that I think is useful is, I think there's a tendency to just put everything into one prompt and expect the AI to return, a monolithic result that includes everything. And sometimes there's a benefit in breaking things down into smaller steps. So like you could take our arbitration demand form, upload that, and instead of prompting it to fill out the entire thing, just say fill out section 1 with this information, fill out section 2. And by targeting the AI onto a smaller, more atomic task, you can get better results, especially if you're asking it to do a relatively complex thought process for that specific task. So it's just another thing to think about. If you're not happy about the result, try to break things down and take it step by step.
So
oh yeah, go ahead.
Oh, I do have another slide, and let me see if I can share and then. Okay. There, there, there we are. So I made a couple of notes, for everyone regarding the issue of ethics and confidentiality, because I know that this comes up, frequently, and these are some of the highlights from those. And in addition to that, I've created for myself anyway, what I call it my practical checklist, and best practices. And it starts with, labeling the content in my work files that have AI assistance with that classification, so that when I'm referring back to these documents, I know where they came from, and what weight to give to them, depending on if it's a research issue or something different. And then in addition to that, I never, as a practice, paste privileged documents into a public model. Enterprise models or a proprietary solution would be, the only. And even then, I think with caution, you should probably err on the side of not including any privileged documents. I actually, in doing this, preparing for this presentation, I made a request of ChatGTP to avoid remembering any private or confidential information that I've provided. And it said to me that, well, we don't store your information, but your prompts are actually stored in your history. And if you don't have a login, then the prompts are stored on the server of the company that provides the tool. But if you create a profile, then you're able to delete, the prompts at will. And so I thought that was very interesting. Another, sort of not highlight, but another, sort of best practices is, and we talked a lot about this, is it involves prompt engineering, including varying the length of terms that you include and request, to Greg's point, you don't want to dump a whole lot of information and then ask it to filter through and do too many things at once, because you'll perhaps be less pleased with the results, as you would probably doing that on your own. Human in the loop, remaining, part of the process, when it comes to reviewing the law, the facts, and the strategy, and then, document, keeping an audit trail of your prompts, and that can also be extremely helpful, because I've noticed that you can take the same prompt and input it into the device at a different time, and it will generate a different result, because it is providing you with results based on the information available to it at that point in time. And in the later incarnation or later time, it has more information or different information, and so it will employ that additional information. On ethical issues, because I think that that's important, and again, it's something that comes up. I think, well, I'm lost in my notes. So this is where I need my AI. I think I came back to the accuracy and hallucination risk. So, AI can invent statutes. And so that was actually part of the crowdsourcing questioning that we were going to do towards the end. And maybe this would be a good time to pose those questions to you. Based on the experiment that we did and the discussion up to this point, I would be curious to know from our attendees, what 3 to 5 things would you think are necessary to be included in a prompt for an AI tool? Maybe you can use the chat feature to share that with us.
So I've shared that with the group in chat. What to request people to put in the most important things to tell AI. And I just wanted to say, for clarity, just because it can seem confusing since you're all AAA affiliated, that the ChatGPT is not a AAA tool. That's just the public version. So the experiments that we've been conducting today don't represent kind of advice or anything proprietary to AAA. It's just thinking about how to use this LLM with, arbitral assistance and AI augmented preparation and learning tools. So I think there was a little confusion about that in the chat about, the ethics of it as well. But just to make that clear.
Thank you for that. I mean, and I should have remembered to say that. These were, I think, some questions that I came up with to sort of generate conversation and discussion among us. But I think that we've done well in terms of our time without the assistance of these questions. But if there is anything here that you would be interested in hearing more about, or if there are specific questions that the attendees have, we would be happy to try to address those as well.
There was one question before asking what proprietary paid system you use, if you're at liberty to disclose.
I don't think there's any problem with me. I do use Harvey. And when I'm not using that, I will use a Opus 4, which is a product of Claude. And I've used Alexa's AI tool, which is helpful if you're, obviously doing research where you want to have access to Alexa's publications because the only way to get them is through their AI. But all of their practice guides, are on or, available through that platform. So you can search them, to the, great extents for lots of different things.
I have a question. Increasingly, we're seeing articles that are published where authors include a statement that this was AI assisted. I'm wondering what your thoughts are on disclosing that you have used AI as part of your work.
Well, yeah, I think that question came up in the AAA as well, whether or not there should be some amendment to the rules. What did you mention that at some point, Adam, or was there a discussion that you were aware of that might have approached that subject?
I think my thought is that AI is all around and it's being used, and even if you don't think you're using it, you are using it. So, disclosure of AI is sort of like it's means nothing, because it could mean as little as you searched one of the terms in Google and got some information, or it could mean as much as it wrote the whole paper for you. So it doesn't provide much information, I think, to do that disclosure.
I do think it's an interesting question in the context, not so much of legal or arbitration filings, but in terms of authoring articles and other content. And, Delton, to your point earlier about how there are certain things that you're going to write yourself because that's just to your taste and you want to do that. I feel that way. I've certainly written content where I've included an explanation as to, how AI was used. I think there is some value in having that sort of transparency, but to Adam's point, it's a sliding scale. Anybody who's using Google or, pretty much any search engine is leveraging AI in some indirect way because it's built into those tools, even if you're not, directly interfacing with it. And, so it's become like air in a sense. And so the more important thing perhaps is not whether you used AI, but whether you applied your own human judgment on top of it versus abdicating that role to the AI.
So we just have a few minutes left. So I don't know if my fellow panel members would like to make a closing remark, or if there is another pressing question that you would out there that you would like to have answered. This slide is now providing you with our contact information. I think it's okay for me to say that we all invite you, to reach out and stay in touch. And we thank you again for, your participation.
There is one raised Zoom hand. Andrew, would you like to?
Yes, one quick question. Can someone provide any comments regarding ClearBrief, which I think is a AAA tool?
It's not AAA's own tool, but we did partner with ClearBrief, and it's currently available for arbitrators to use. Without going into a whole ClearBrief demonstration, it essentially, you can load in the case documents. It'll help you prepare a timeline of events. It'll site check for you, but it's very much, they have all sorts of guardrails and safety measures in place so that it isn't generating content and producing any hallucinations, as I understand it.
Yeah.
Thank you so much.
Yeah. So I think to Adam's point, it's a closed universe rather than, an open universe. It's not finding information from the outside, and importing it, into your into its search results. it's using your input, and only your input. So for me personally, I use it to summarize and to create timetables. When I'm presented with a wealth of information in terms of documents, that it's very, very, very helpful in that regard.
Thank you. Much appreciated.
We are at that 10 o'clock point. I can't thank the three of you enough. Delton, Adam, and Greg, this has been a terrific presentation, and look forward to seeing everyone again next month. Thank you, Nikki, for your amazing facilitation of the chat. Thank you everyone for coming. See you next month. I think we did say that we would stay on for a minute or so if anyone had any last thoughts informally. So we are going to turn off the recording. Delton, Greg, Adam, if you have a minute to hang around, if anyone has any questions that they would like to ask or comments they would like to make off the record.